Yes.
Zoom recording,
Vai pode.
and then I'm going to Zoom. There we go. Live on Facebook. Okay. There we go. Oops. Okay. Okay.
Okay.
I think we are live. So welcome everyone to another informational webinar hosted by PALCUS. Today, we are talking about real estate planning and inheritance with Sandra Gomes Pinto, who is the founder and owner of SGP and Associates law firm in Portugal. Thank you, Sandra, for joining us today. This is a really important topic because PALCUS is a national organization. We get tons of questions about, I inherited property from my parents, but I've never been to Portugal, or I haven't been in a long time, or I'm not a citizen, and how do I do this? And do you know somebody? So we get questions about this all the time. And so I'm really excited that we have a webinar that's going to really cover a lot of topics that we get questions about almost every week. And just so very quickly, if you find this webinar really helpful and you think we should do more of these, PALCUS would love to have you as a member because it's because of the membership dues that fuel our working environment here, that allows us to do these types of webinars. So at the end of the webinar, if you feel like this is really helpful, we ask that you become a member, and you can do that on our website. I'm going to turn it over to Sandra. Sandra, thank you so much for joining us. I know you're going to talk a little bit about your firm and that you work a lot with both Americans and Portuguese Americans and even people outside the US on these types of issues. So welcome and thank you for joining us.
Hi, thank you. Thank you, Angela. It's a great pleasure for me to be here and to talk about this. It's a great pleasure to be helping PALCUS or be joining an event from PALCUS. We are very happy that there is an organization that gives a voice to American Portuguese. And me personally, as a Portuguese, I was recently in San Francisco, and I was super proud to see how many successful Portuguese there are. But I think definitely to have a Portuguese American community in such a competitive market, in such a competitive and sometimes in such a competitive country, definitely it's very important for people. For sure, it can have a big impact on development, on leadership, on the American Portuguese community, and for also to preserve the Portuguese heritage, which I think it's very important for all the Portuguese American and all the Portuguese in general. So thank you so much for allowing me to take part of your fantastic project. It's also a pleasure to do this with you, Angela. We were in San Francisco, people refer to you. You portray a successful Portuguese woman in the tech business in such a man's world, the automobile industry, which is definitely a man's world. So you must be good for sure to be able to have a role in this man's world and in this competitive market. So it's also, we are a firm mostly of women that want to do a good job, that are very committed to our clients and to the well-being and to provide an accurate and good legal service to our clients. So it's a great pleasure to do this with PALCUS and with you. And I urge, we did send a newsletter to some of our clients, so I urge them also to join PALCUS, and we as an office, and if we can, or me as a private person, of course we will join PALCUS, because We do like this kind of, we cherish what you're doing, and cherish you, a co-founder of such an interesting project.
Thank
Yes.
you. Thank you very much.
Yes.
So do we want to just jump into the questions that we already have
Yes,
from
yes.
readers? Okay, so
Let me just do a disclaimer that
sure.
perhaps we won't address each person's case. So for the first 30 that contacted us, send us an email, and we will try to address your specific question, and even to get for the 33rd to give a private Zoom, so we can address the case, because in these times runs always very fast, and it's difficult to address specific questions of each person. So as a disclaimer, I apologize, and please come back to us, that will provide the answers.
Right. And so if you're attending on Zoom, please pop your questions into the Q&A box. And if you are watching on Facebook, please post your questions in the chat, and we will try to get to as many as we can. But we're going to start with a question about wills and inheritance, especially ones that involve cross-border situations. So US and Portugal, right? These are pretty complex matters. So what's your advice in pre-planning for these kinds of situations? Because we get a lot of questions about the after, right? Someone has already passed away. Now what do they do? So what's the pre-planning part that you recommend?
So when there are an inheritance that has cross-border issues, that means that there are more than one jurisdiction involved. And sometimes, for instance, with Europe and US, we have jurisdictions which completely different systems and principles. You have the common law, we have the civil law. So it's completely different. And when someone dies, it's always a dramatic event. So, and people are not in their best conditions to make decisions and to take care of bureaucracy. So I think, especially in these cases, it's very important to address problems beforehand and to try to prevent. And one of the main questions, and whenever there is an American or American Portuguese and involved in a inheritance process, it is always important, and many times it's possible to choose the applicable law. Podes me ajudar, Inês? It's I lost you. I don't know what happened. But the phones always ring in the
Yeah,
wrong moment. I don't know. I
right.
said I
No problem.
switch
We
off.
still see you.
So whenever there are two jurisdictions involved and with different systems, problems are much more complex. So one thing that should and could be addressed beforehand is what law is applicable. In many cases, it is possible to choose the law, but it's possible before someone dies. It's possible to address that in a will. And I really urge people to do so, because that can make things much simpler. For instance, I don't know if most of you are aware of that, but in Portugal, we have the regime or forced heirship. So you cannot skip your children, and your spouse would be your primary heirs. So unless they did a terrific crime and they were condemned in a definitive way in respect of this crime, you always have to have them as your mandatory heirs. As a general rule, you can only dispose of 1/3 of your assets. So if you don't want this regime or forced heirship, and if you have assets in Portugal, and if you have American citizenship or a connection with the US, it would make all the sense to have a will made and to establish that you want the will in Portugal if you have assets, especially if you have registered assets, and to establish that you want the US law to be applicable if that is the case, or that you want the Portuguese law to be applicable, or that you want the Portuguese law to be applicable for some stuff and US law applicable for others. So there are lots of possibilities. It's difficult to talk about all of them
Right.
beforehand,
So case
but
by
it's Yes, but it's possible to plan, and it's possible for you to nominate an executor that could help with the inheritance process in Portugal.
Hmm.
If you are living in Portugal and you have children here, it is possible, a young minor, it's possible to establish who should take care of them. Although this will have to be confirmed by the public attorney afterwards. There are many things that could be addressed in a will and should be. And so if you have registered assets in Portugal, I think it could make a huge difference to have a will,
Will.
at least for the Portuguese assets. And if you have assets in Portugal and assets in the US, and if you already have a will in the US, it would be important to have a will in Portugal to mention that this will would only be applicable to Portuguese assets, that you already have a will in the States for American assets, and that this will not revocate, because there's a rule that a new will revocates the previous one, that this new will not revocate what you already established in the US will. So I think really to prepare, to plan. I'm a litigator, and I was litigator in big oil and gas cases and construction
Hmm.
cases. But now I'm a big advocate for trying to sort and to look for alternative mechanisms to resolve dispute resolution, to avoid litigation, and especially in inheritance matters, in a family context, this can be very damaging for one's personal life. So to
So,
address problems previously,
mhm.
to see how can they can be solved in an earlier stage. For instance, I just we were talking, and I just said to you that heirs, in order to inherit an asset in Portugal, should have, it's mandatory to have a tax number, a NIF here. So if
Hmm.
you have an inheritance, it would be important that you create NIFs, tax numbers, for your presumably heirs. That
They
could
can
make,
still do that. They can still do that even if, okay, the person's
yeah,
passed,
they
their
could,
children don't have a NIF, but they can still
yes.
create a NIF. Okay.
But you know, this kind of stuff, it's more complicated to deal with this after such a tragic moment as the death of a loved one. So,
Hmm.
and especially navigating a process and a systems that you aren't familiar with.
Right.
So,
So I wanted to jump in with a clarifying and also another question. So when you say you can choose which law is applicable, you can actually say, okay, yes, we have some assets in Portugal. You can't get away from the forced airship issue, but then for other things, can
you
you
can,
say,
you can,
oh, you
you can,
can?
you
Oh,
can,
so you can
you
say,
can,
listen, I
yes,
want US law applied to my
yes.
assets
If
in
you have
Portugal. I don't
connection
think
with
people knew
the,
that at
yes,
all.
if you have a US connection, if you have US citizenship, you have the possibility in many cases, this will have to be analyzed according to international private laws, clauses and everything, but in many cases you can. And this is the
Interesting.
good thing. And in
Really,
Europe, really can. We have a system that allows you to choose the
very
applicable
interesting.
law. So,
But that can only
yes,
be, you have to choose that before they pass away, though, correct?
yes, you cannot do afterwards.
Darn it.
So
Okay.
this is, as always,
Okay.
planning and preventing. And for us, Portuguese is super important because we are not that good. We are good in solving problems and problem solving in a creative way, very rapid way, in a very quick way. But planning and preventing and financial literacy, yes, financial literacy for Portuguese women would be a top webinar because this is a big, which I talk with hundreds of American families. So this is a big difference that for me, it was a discovery. The
Yeah,
financial planning of the American society has nothing to do. For us, it's unknown land. It's completely this.
interesting.
Yes,
Okay.
that
We do
is
have
really,
we
yes.
have a couple of questions that have come in on
Yes,
Zoom. So again, they're going to be specific cases, but we're here to
yes.
answer questions. So
course.
With the recent passing of our mother, my brother and I inherited family lands near Coimbra. We were
Mhm,
also recently approached by the Cartório
mhm,
Notaria that
mhm,
a neighbor of one parcel claims ownership. We
mhm,
need guidance on our ownership rights on this parcel and have several other larger parcels we'd like to properly document, title, and protect from seizure.
mhm.
This is a
Yes,
very common question
this
we
is a
get all the
very
time.
common.
My
Yes,
uncle's trying to take my
yes.
dad's land just because we're not
Yeah,
there. Okay.
yes. Now everything it's easier in Portugal because the register is everything online and you have a register name, a certidão predial, certidão permanente, and just with a number you can access of the situation of each property. So now for the new properties and most of the old ones, um, it is registered and everything is clear, so it's quite safe to acquire property here. For the old ones, it would depend on the documents and papers that you have, but you can also challenge and verify on what grounds the other person wants to make a deed to say that the property is their own property. So this could be analyzed and verified and challenged because you do have to have documentation that proves and that enables a person to declare in a deed that the property is his, and that allows them then later to register that property and that before the land registry. So there are in old properties there is some places for some less decent persons to play some tricks, especially if the other heirs are very far away. So it's a question we have to analyze the case, but this should be analyzed by a lawyer, and you could challenge if they have enough documentation and enough
Okay.
proof to declare that the property is theirs, and not yours,
Got it.
or not part of your inheritance.
Okay. Another question. We are an American and Dutch couple living in the US and are interested in buying property in Portugal to rent out and use for our own vacations. Can we
Mhm.
do this without living in Portugal or even in Europe and with one of us being a US citizen?
You can do it without any type of restriction, without living in Portugal. Here,
So,
you can even do it without coming here.
so you can buy a property sight unseen, but you need to
Yes,
have
yes.
somebody in Portugal acting on your behalf,
Yes,
I would imagine.
yes, you can do a power of attorney. The lawyer will have to create a NIF, a tax number here, a bank account here, and we do work with the CGD, which is the state bank. And by the way, we will do a next webinar with CGD, with the state bank, about mortgages and loans in the 2nd of May. And so you can buy property, you can even get loans credit to buy this property and to rent it out. You will be taxed as non-resident. At this moment, the tax rate is 28%, but it's possible to deduct all the expenses that you had buying the property and doing and maintaining the property. So you can do it without any type of restriction, and you can even do it without coming to Portugal. And at this moment, there are so many Americans. We are contacted daily from lots of people. So there are
Mhm.
so many Americans coming here that buying, for instance, the place where you have the house in Cotovia. We have lots of Americans renting annually in Sesimbra for D7 purposes, and in Cotovia and in similar places. So at this point, investing in Portugal also for the people coming here that do need a proof of accommodation is one of the requirements of the D7, the passive income visa. So the rental market is hot. So I think it's also an interesting market to invest. Of course, I'm biased in
Sure.
that respect.
Right.
Completely biased,
So,
but I think it's a good option.
so
Yes.
you talked about the importance of having a will, establishing a will, before the person passes away.
Yes,
Here in
because
the
it's not
US,
possible after a person passed away.
right, right. So here in the US, we have something called a living trust, which a lot of people have
Yes,
done,
yes.
which is different than a will.
Mm.
So can you talk about, the different types of wills in Portugal, and is there an equivalent to a living trust, something that's similar to that? And then how do you make a will? You have to use a lawyer, a law firm, correct? Yeah.
Not necessarily. You can
Oh,
go
okay.
directly to a notary if you wish to do so. But I think to have, especially if there are two jurisdictions involved and it gets more complex, I think it could make all the sense to have a lawyer and to have proper counsel in that respect. But a notary does it. There are two types, a public will and a private will. The public will be done by the notary and it will be inserted in their books. And there is the private will that can be done by the testate, the person and or the lawyer, and has to be approved by the notary and will be in their files. I think a public will is a very good option, but unlike the name, it is important to clarify that a public will is absolutely, it's not public at all. It's completely secret and it should be. It's for those that are acquainted with inheritance and inheritance law. And for notaries, it's very clear that it's important also for the peace in the family that once a person does a will, it remains secret and nobody can access, not even the lawyer that did it, that help the person can access unless there is a specific order to do so. And it's important to that it remains secret because it can cause lots of family drama. And this is before being a lawyer, this is something I was not aware of, but this is how it
Mhm.
is.
So if it's secret, so then how do the heirs become aware that there's this will? Like, especially if,
Mm.
someone hasn't been to Portugal in forever and all of a sudden they get this phone call, your grandfather passed away and you're
So there's two institutions that you can talk to know if there is a will in Portugal. Is the Central Registry Office or the Institute for Notaries and Registry.
okay.
São registros centrais and o Instituto para o Registro e Notariado. So the Central Registry and Institute for Registry and Notaries, they will say whether this person has a will because they have everything centralized and registered, all the wills existing in Portugal. An additional element, if you want to know if your parent or grandparent had an account in Portugal, then you can go to Bank of Portugal. They should
Okay.
provide, you have to present the proof that you are an heir. It would be the deeds that proves that you are an heir. It's called the Escritura de Habilitação de Herdeiros. And with these elements, you can assess which, if the person has or which accounts the person has in Portugal.
So can you talk about that document, the proof that you're an heir? And it sounds like that you have to get that in Portugal. So again, if you're here in the US and all
Mhm.
you have is your birth certificate here saying that that was your father or your
Mhm.
mother or whatever, that's not sufficient. So how do
Yeah.
you get this a bit,
So this
I'm
is
gonna
done.
not say it properly, but
Yes.
habitação?
So how can you get this done? So this is done before a notary. We
Okay.
have a figure that's called in Portuguese cabeça de casal. It's the head of the couple, being a literal translation. So it is the person who would be the administrator of the inheritance. This person has to deal with legal issues, to take care of things, to deal with urgent matters, to deal with registries, to deal with leases if there are any leases in the inheritance, to deal with the bureaucracy, the formalities. This person should be entitled to do and to prepare de escritura de habilitação de herdeiros and to declare also with two independent witnesses who the heirs of this inheritance are. And if there are false declarations, they should be punished legally. It's a crime of false declarations if someone omits an heir. So it's quite important to do it in the right way. So it's you to prove that you are an heir of an inheritance in Portugal. It's important to have the escritura de habilitação de herdeiros, which is a deed done before a notary. It should be the couple, the head of couple, the administrator of the inheritance that does it, and it should be supported and confirmed by two independent witnesses, not related with the family. So this is a proof that you are heir in Portugal.
Wow. Wow. Okay. So you talked about how to find out if there's a will existing in Portugal. Is it the same process to find out, okay, did my father have a bank account? And which bank?
Yes. Now, then you go on to know if there's a will, you go to the central registry and you go to the Institute of Registry and Notaries. If you want to know if your father or your mother or your grandfather had accounts in Portugal and which accounts, you go to Banco de Portugal, to bank. So it's different institutions.
So Banco de Portugal, they're going to know if you had an account at CGD or
whatever. They have everything is registered there.
Got
it.
They
should
Interesting.
Have all the information.
Okay. And then, so to do a lot with regarding citizenship, it's always, you know, the first step, register your marriage. So is there a requirement to register your marriage in Portugal for inheritance purposes? And if so, maybe in certain situations there would be, but can you talk about that?
Yes, it's for citizenship purposes, definitely, for inheritance purposes also, and for any purpose, because if your marriage is not transcribed here in the civil registry, it cannot be enforceable here. We know of a case of a person that had an American woman that had the body of her husband, and some Portuguese authorities didn't acknowledge her as wife, and being with the possibility to say what to be done with the body because the marriage was not transcribed. So this is, if you are moving to Portugal, living in Portugal, if you have inheritance of assets in Portugal, to transcribe your marriage is a must, because if it's not transcribed in Portugal, it should not be enforceable for any legal issue in Portugal. So it's quite important. This is a basic.
So there's a lot of situations that we could talk about, but for example, you and your husband have children, right? And your husband inherits assets from Portugal, but he's passed away. But you want your children to benefit from his inheritance. But if your marriage isn't registered in Portugal, then it won't be recognized.
Yes.
Your children are out of luck.
Yes, it is not your children, but your children prove that they are children with a birth certificate, not with a marriage. But but to deal with an inheritance that involves your past husband somehow in Portugal, you need to have, and you want to present yourself as wife and defend your rights somehow as wife. It will be also always mandatory to have your marriage transcribed here. Okay?
Right. Because I think to register a birth, you have to first register the marriage, correct?
Yes.
Yeah.
Yes.
Okay. There's something called a vital testament, which I had never heard of. Can you talk about that, and what is it used for? How do you get it? All those kinds of things.
So, a vital testament is a testament that to be done that, for instance, if you are unconscious, uh, who should take decisions on your behalf, or and what decisions should be made. And also, if you pass away, if your organs should be doned or not. It's important to declare that Portugal is quite on the edge here, because in Portugal, as a default rule, uh, the organs can be doned if the person doesn't establish otherwise. But if you don't want to donate your organs, you should establish in a vital will that it is done. It can be done through different entities, but it can be done before the health ministerium here. It has to be registered. It has to validity of 5 years. So every 5 years you have to renew it to be valid.
Mm-hmm.
And this is it can be important, if especially if you have specific guidelines that you want to give, and especially if you want, if you are unconscious and their decisions have to be made about what procedures to take. It would be important that you address specifically who you want to take these decisions on your behalf. So
Got
this
it.
is, if you're living in Portugal, if you're have a certain age, it makes all the sense to have also a vital will.
Okay. So we did get another question earlier in the week that I wanted to make sure that we addressed, because it has to do with inheritance, as far as what are the property lines, and where does it start, where does it end? And the
Mm-hmm.
question was around surveying and establishing those property lines and the process for that.
Mm-hmm.
The question was, um, is there a standard way of doing it? Because this person, literally, is true story. Their survey of the land was, 30 feet from the rock on the
Mm-hmm.
corner here. But what happens if that rock gets moved?
Mm-hmm.
Or somebody deliberately moves the rock, right? And so, can you talk about the surveying
Yeah.
process and
So this
how to
this
avoid situations like that?
there is no one. This could be also addressed case by case. This should be addressed judicially. So you should, if you want, if you cannot enter into an agreement with the other person, you should litigate. This is the way to handle this kind of issues. But it's all about the proof that you have, the written proof about the location of the rock, and also the persons that could witness that someone changed the place of the rock. And there is specific litigation in this regard, but it can be complex. It can take a lot of years, and there can be very different outcomes in this situation. I'm an experienced litigator, so I know this is challenging in Portugal at this moment to litigate.
Right. So there's no like, uh, you know, latitude and longitude markers on a land that you can say, the
Yeah,
rock was
there
at
should
this
be that,
latitude and
yeah,
longitude.
there should be, and there should be some, but if it's very old registry, it can be complicated. But
Sure.
there could be, before the city council, gets more and more accurate, but not in all the places. So the city council should be able to declare, to establish, to declare what are the limits. But there might be challenges here, not always.
Okay. Just a reminder, if you have questions about a particular situation you're facing, please pop them in the chat in the Zoom or in the Facebook live chat, and we are happy to answer them live here in our session. Let me get to our next question on the list. We do have a question here. Is a trust recognized in Portugal? So I'm gonna assume like a living trust,
Yes,
a U.S.
yes.
living trust. Is that recognized?
It's recognized, and there are similar, but we don't have this figure. With the Portuguese normally don't use it.
Okay.
But they are similar, or there are at least institutes that are some kind of insurance that may play the same role, but we don't
Okay.
have the figure.
Okay. And then can you give a sense of, when someone passes away, um, registering their death, how long does that take? How do you transfer their bank account into your name, that sort of thing? Because, familiar
Yes,
with how it works here,
yes.
but not familiar with how it works over there.
So if a person dies in an hospital, normally the death is automatically registered. If not,
Okay.
you need the declaration from a doctor to register it. Afterwards, it should be declared before the tax authorities, and you should do the escritura de habilitação de herdeiros, which is a deed where you declare who the heirs are. Normally, the wife or the oldest child should be the head of couple and should be the administrator of the inheritance and should be the person in charge of these formalities. Then, after you declare who the heirs are, also with the deeds, and it again, I would repeat, it has to be two independent witnesses confirming who the heirs are. And if someone gives a false declaration here, this could be criminally punished. Afterwards, if the heirs enter into an agreement how to divide the inheritance, they do another deed, escritura de partilha. And if people don't, if the heirs do not agree, then they would have to sort out mechanisms to dispute, to solve disputes, the dispute that they might have. So litigation would be the normal litigation in the Portuguese courts, if the Portuguese courts are competent to deal with the specific matter, should be the way to divide the inheritance. So this is basically it. As an important issue, I think I would add, and I think this is quite attractive. In Portugal, there is no inheritance tax for direct heirs. For the spouse, the children, the grandchildren, the parents, the grandparents, they do not pay taxes to the Portuguese authorities. There is no inheritance tax. There
Okay.
is a minor stamp duty. So this can be very attractive. This is quite attractive from a tax perspective.
So will the US government try to claim inheritance tax if it's a Portuguese property?
He should not, because it's a Portuguese
Okay.
asset. And if you have also Portuguese citizenship, although the US, unlike the majority of the states, you have a very strange system that you tax based on citizenship and not based on residency. So
Hmm.
I cannot speak for the US authority, but I think US authorities should not tax, especially if you also have Portuguese citizenship, if you have
Right.
asset in Portugal. So the income generated for this asset should only be taxed in Portugal.
Okay. We have a question here. My mother, who is a Portuguese and a US citizen, was told that she will inherit her godmother's home and land. Her
Mhm.
godmother assures her that she is the heir, but will not provide information on where the will is. Who should
Mhm.
my mother contact upon her godmother's death? And can she find out before death if she is entitled to anything? So I think you said you go
Yeah,
to the central registry, right?
yes, or Institute of Notary. And as I previously said, the will is completely secret before someone dies. So she cannot find out before the godmother dies. And when the godmother dies, the godmother might have the document in her possession, so she might be given the document. It is sometimes useful to have a lawyer that has these documents and will be nominated as executor of the will and should contact the heirs. I think that could simply, if you have someone you trust, that could simplify things. But you can also always call and contact the central registry or the Institute for Notaries and Registries here in Portugal.
So she just has to wait. Because even if she contacted the central registry and they said, yes, there's a will here, but you're not going to know what's in it. I mean,
No,
I think that's,
probably they won't answer before the
oh, okay.
partner dies.
Got
Yes.
it. Okay. And I think that's standard here too, right? Like I can't
Yes,
find out what's in my parents' will if they don't
yes,
want me to know, right?
yes.
So yeah, okay, that's pretty
It
standard.
makes all the sense that is so.
Yeah,
This what the studies about this family matters
right.
show. Yeah.
We have another question. Can parents gift a house instead of giving it as an inheritance? So can they gift it while they're still alive instead of leaving it as an inheritance once they've passed?
Yes, they can, but in Portugal, it would if they are going to give that to a prime heir, to one of the children, or it can be taken into account in the division of the inheritance. It's called colação. So it's in the division of the assets between the siblings, it should be taken into account that the parents donate something to another one of the children.
Of equal value or just
Yeah,
donate it?
yes. Yes, if they donate something, that should take into the account into the division of the assets of the inheritance in respect to the other siblings.
Okay.
This is called
So,
colação in Portuguese law.
okay. So maybe can you explain that how, the division of inheritance when there's, siblings and still a living spouse, right? Because that can
Yes.
get a little complicated. Because then what you're saying is, yes, I can give my house to this daughter, but then I have to give that daughter something of equal value.
Or if I give to this daughter, this will be taken into account when I die in respect to the division of my inheritance.
Ah, so she may not get anything else after you pass
Yes,
away.
yes.
Got it.
Or she will
Okay.
have to reimburse the other siblings of money if the rest of the inheritance is not enough to do an equal division, because the parent should only be entitled in normal cases to dispose of 1/3 of their
Mhm.
assets.
Got it.
So,
Now, throwing a loop here, this is not part of their question, but to the previous comment about choosing the law, could you say, well, I want US law applicable here, and
mhm.
yes, one daughter gets everything, the other two get nothing?
It
Could you
if
do that if you said,
Yes, yes,
okay,
yes. You can do that if yes, you can do that if you have enough grounds to have the US law applicable.
and
You have
what would
just
be grounds for that?
yes, if you have US, if you reside in US and if you are a US citizen, that would be enough grounds.
Okay.
Or if
Follow
you
up.
reside in Portugal and are US citizens, that would also be enough grounds.
Okay. So follow-up question to the division of the house. Is the division of the house the current value or when it was inherited?
It's the I didn't understand the question. For
So
what
I guess,
purpose? The value of the house for what purpose? It's when they are dividing the assets. It's about the moment of the
so the
inheritance.
current value.
Yes, the current value. Yes.
Got it. Okay. Um, and can you talk a little bit about, this is in the line of, heir inheritance, but when the heirs are also married, what's the role of the spouses of the heirs when it comes to inheritance?
Yes. So just imagine. Let's do a very concrete example to make it easier. There
Okay.
is a house, and the marriage system is joint assets. So the spouse would be own 50%, already 50% of the house.
Okay.
If you think inheritance, it's just a house. So the rest of the 50% of the house should be divided among the wife and children
Okay.
in equal parts if there's no will.
Okay.
If you want to do a will and if you want to protect your wife as much as you can do a will and say that your wife will inheritance 1/3 of your inheritance. So that the 50%, 1/3 of the 60% would also be for your wife, and the remaining parts would be equally divided among wife and children. Because you can still dispose of 1/3. So
Got it. Okay.
50% are already from the wife because you have joint assets. And
Okay.
then from the rest 50%, you can dispose of 1/3 of 50%, which would be 1/6, and the remaining 2/3 of the 60% should be divided equally among all the heirs, including
Heirs.
the yes.
And what about the spouses of the heirs? Do they have a role in anything?
No, because normally, when something is inherited, unless you have a total, there is all the only joint assets. If you have a specific regime, the inherited assets are private assets from one of the spouses. So if you inherit a house as a Portuguese person here in Portugal, if you inherited a house, is your own private asset. It's your, even if you have the joint regime of assets, your husband is not, will not inherit this asset.
So you
But
could sell
here,
it and not, and your husband doesn't have to
no,
sign anything.
not necessarily, because many times when it is a house, your husband still has to sign, and especially if it is somehow the family house, then even if it's your own private assets, your husband will have to sign too. And even if you have separate assets, it would be important your husband will need to, you need to have a tax number for your husband and to deal with it.
Okay.
If he's not the owner.
So let's say both parents have passed away. Okay.
Mm-hmm.
You have 3 children, 3 heirs,
Mm-hmm.
and all 3 heirs are married.
Mm-hmm.
They want to sell the house.
Mm-hmm.
Can the 3 heirs themselves sell the house, just the three of them? Or do the spouses of the 3 heirs have, can they say, no, 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 we should keep the house? And one of them cause a problem, right? So what I'm asking is, can the 3 heirs make the final decision on whether or not they sell the property? Or do they have to get, the okay from their spouses as well?
It depends on the assets regime. But if they have separate of assets regime, they don't need the approval of the spouses. If they have the default regime, many cases it's needed the written approval. And if they only have common assets, because there is a special regime that is not the one applicable by default, you have to do a convention before marriage to have this applicable. In this case, there is a possibility of the spouses also to inherit your parents' house, but it's not common, but it might happen. But
So,
even even if you have separate assets, and I had a Swiss that a Portuguese that was married to a Swiss, and she had the regime of separate assets, so he was not, they have completely separation of assets. But even though in an inheritance case, he needed to get a tax number here, even though he would not have an active role in the inheritance procedure, it was important. Without his tax number, we could not take care of the case.
interesting. So when you say it depends on what kind of regime they have, is that, when would that regime have been set
Made.
up? Like, so,
It has to be made before marriage. You can have the regime applicable by default, which is joint assets. Everything you earn after the marriage should be joint, unless it is received by a donation or inherited.
Okay.
This is the regime applicable by default.
And how
And
would you find out about which regime they have? Is there like a document that says this is
yeah,
the,
there is
okay,
a document, the marriage certificate.
okay,
And
so it's
if
different
it's
than a
not,
will, though.
yes, yes, it's different than a will. And if it's not in the marriage certificate, if you are not applying the regime applicable by default, it's necessary that you made a convention and registered it before the civil registry. So you have to present the convention that allows you to apply a specific assets regime.
Okay. This is also sounding a little bit more kind of like a prenuptial agreement.
Yes, yes, exactly.
Okay. So you have those as well, but it's called a convention or a regime?
Yes, it was a convention. It's the
Okay.
literal. It's a prenup. Yes, it's a prenup. It's basically the same thing. But as you know, I don't know if it is in Portugal, is immutable. So you can once you make it before marriage, unless very, very exceptional situation, you cannot change it. Cannot be changed.
Okay. I don't know if that's the case here in the US either. But that's good to know. Um, okay, we do have about 9 minutes left in our webinar. So if you have some questions, please pop them into the Q&A box or into the live chat. We do have another question here. If an expat dies in Portugal, which law shall be applicable to the inheritance? And I guess that will depend on a few things. Does he have a
Yeah.
will? Does he have a trust? Those
Yeah.
kinds of things, right?
Yes, and is he a US expat or is he European? Because the law applicable by default, if he's US, it will be the international private law rules established in the civil code. And by default, the first law applicable should be the law of nationality. If he is an European, there is specific European legislation about that, Rome 4. And so by default is the law of residency, but in both cases, it's possible to choose the applicable law. So it
Okay.
will, on the concrete case, it will depend.
Okay. I have another question here. If I plan on selling inherited land in Portugal and will be visiting to handle this, what documents do I need and do I need a bank account?
If you're doing any kind of deal in Portugal, could make all the sense to have a bank account here. It
Okay.
simplifies things a lot. So you would need the documentation from the house. You would need the deeds that proves that you are an heir, and you would need the intervention of all the heirs if this property, the asset, was not yet divided. So all the heirs should intervene in the deed to sell it, and you need the deed that proves that you are an heir of the property, and all the documentation related to the property, the tax,
Okay.
the registry, uh, everything that you need to the property. There is a certificate of energy efficiency that now is required. So you have to have all the documentation, a deed that proves that you are an heir. If the asset was not already divided and it's not in your name, all the heirs should intervene in this process.
That's a lot of paperwork. All right.
Yes.
Okay, so we have another question.
Lots of paperwork in Portuguese, so it will, yes.
We have two questions related to a US living trust talking about Portuguese assets. So I'll read the question. If it was written in a US living trust that the Portugal assets are to go all to one child, is that sufficient, or do they need to also have a will done in Portugal that specifies the same thing, that just one child will get everything?
I think it would be to have it applicable in Portugal. It will be easier if you are still in the planning mode. It's
Mhm.
better to have a will, and there will be an inheritance process that somehow will involve Portuguese authorities, you should have it in a Portuguese will because it makes things so much easier.
Okay. But in the sense
You
that
should have a Portuguese will establish that the US law would be applicable
I was
because
just gonna,
according to Portuguese law, we have forced heirship. You cannot say that to go all to one child. So you have to have a will. You have to establish that the US law would be applicable. But if you
got it,
want US law to be applicable in Portugal, I think it's always best to establish expressly in a will. Otherwise, by default, despite what the law says, the Portuguese authorities would always tend to apply the Portuguese law. This
okay.
is
So,
always like that in each country.
okay, so yes, and someone else asked, do you need to update your living trust in the US to include assets in Portugal? Yes, you could do that, but then you also need to have something that says, I choose US law to be applicable when I pass away.
Yeah.
That you can't do that after the person passes away.
No,
Got it.
no. You
Okay.
can't.
So
And
follow
you
up.
should mention that this Portuguese will would be applicable to your Portuguese assets, and you should clarify everything that you can clarify.
Got
And
it.
if possible, you should get NIFs for the heirs, someone you trust to help the heirs to navigate the Portuguese bureaucracy system and so all of these could be done.
Got it.
Previous.
So here's an interesting situation. You have a husband and a wife. Okay.
Mm-hmm,
The husband dies.
mm-hmm,
He has a child from a previous relationship.
mm-hmm.
Okay. But he dies first. So how does inheritance work in that regard? Because you have a wife and he has two children. He has two children, even though the wife is not the mother of one of the children. You know what I mean? So will it still be split like normal? This
Yes,
normal inheritance law?
there are several possibilities. If it depends on if we're talking about a house, if the house is only his or it's also from the wife. If the house is only his, if the assets, it was a private, a totally separate assets, and the house was only from the man, then it will be divided equally among between the spouse and the children. But even though the wife would, if it's the family house, the wife always has special rights to still live in the house for 5 years,
Mm-hmm.
for
Mm,
years.
okay.
So she always has special rights. But if it's only his assets, if she was not, if it's not a joint asset, it should be divided equally among his children and his wife.
Okay. And is I don't think there are, but there are no differences between uh male female rights, right? Like whether it's the husband that dies first or the wife that dies first, it doesn't really
No,
matter.
no, no,
It's
no,
the
no,
same.
no,
Right.
no.
Okay. The
For
other
all time.
question,
Since 25 de Abril, it's all the same.
okay, good to know. So then the other question too is, does citizenship matter? So let's say in this situation where there's a half sister, right? Uh, or half brother that lives in the US and is not a Portuguese citizen, but then the other sibling also lives in the US but is a Portuguese citizen. Does that matter? Like, does the one that is a Portuguese citizen have a little more say? You know, they have a little more
I
influence or
think for the
rights.
Portuguese citizen, it might be easier to navigate the Portuguese bureaucracy. I see he might have some connections that would be helpful, but what it is relevant in terms of inheritance if the person is the deceased person in terms of the applicable law. This is the person that's more relevant
Mhm.
to determine, to clarify which law should be applicable, not the children.
Okay. Um, so then a follow-up to this same situation. Um, so the I got it a little bit confused. So it's actually um I got it back. So it was the mom is the mother of both daughters, but the dad died first. The assets were under both husband and wife's.
Mhm.
So does the half sister inherit immediately or only upon the mother's death?
No, she inherits immediately.
Immediate. Okay.
The question of how they will divide it and how the process will be going, it will depend on the persons and what they decide to do and how.
Okay.
But the half sister can also always use litigation if she's not happy with, and she thinks that things should be divided to get the assets divided and to
Got
get
it.
her.
Okay. And last question, and then we're gonna wrap it up. Let's say you have a couple, one of them passes away, and the other spouse realizes we don't have a will. Can the living spouse then create a will?
Yes, she can create a will for her inheritance, not for his.
Okay. And that could be so, and would she, so let's say, okay, he passes away, there's no will, so it's default split, how Portuguese law
Yes,
says forced
yes,
heirship, right? So
yes,
she has to wait until that whole process finishes, and
yes.
then she can make her will.
No,
Would that,
she can always make her will, but her
okay,
will only be applicable to the assets that she possesses by the time she dies.
got it. But if she wants her will to include whatever she's going to inherit from her husband,
Yes, no, but
so
she
yeah,
can do it immediately. She can do
okay,
it immediately because
okay,
it will only be applicable to the assets that she possesses by the time she dies.
okay,
She can do it whenever she wants. She has totally do it freedom to do it. She doesn't have to wait to end the bureaucratic process of her husband's inheritance. She can do it whenever she wants
got it.
because
And
it.
then I know I said this was the last question, but it reminds me of something else. So let's say the remaining spouse, yes, we want to do a will, but maybe she has dementia.
Mhm.
So what do you do in the situation where she wants a will, but maybe isn't mentally capable to, or deemed mentally capable by the courts to make a decision?
That if you're not mentally capable to declare that someone is not mentally capable, you have to go to courts in Portugal. And only when you have a final sentence saying that this person can not decide by herself, you would have someone deciding on her behalf. And
And the
then,
courts would decide who that person is.
yes, and that person might be able to do a will under certain circumstances. So, but then again, this also might be challenged.
Got it. All right.
But
Well,
if you have dementia, nobody can say that. And I had some cases of this, some litigation about this, and it's extremely difficult when even when you have lots of proofs, if you don't have a declaration by a judge that this person is incapable of taking the decisions and so is declared incapable of taking the decisions, it's very difficult to challenge a will.
good to know. Okay.
Even if you have medical documentation assessing and proving and talking about dementia, if it's
Hmm.
not completely black and white, it's very challenging. But it
Okay.
because inheritance, you for me as a lawyer, I found out so much about not good things about human nature
Mm.
uh, whenever I had inheritance cases. What people are able to do, what kind of neighbors get the best friends of all people, and what kind
It,
of
it
it's
unfortunately brings out the worst in people.
yes, yes,
Yes.
definitely.
Well, this has been so informative. I feel like we probably should have another one. We had a question about when are we going to do the webinar on mortgages, so I think we have to get that on the calendar. Next Monday, we have one on the changes that have happened in citizenship and the citizenship process. So we will be doing that next Monday. So those of you watching, join us then. We will be providing Sandra's contact information. So if you want to work with her and her team, you can reach out to them. And then I will also say, you know, if you found this webinar helpful, and you were like, oh, this is so amazing, I would have never found this out if it wasn't for this webinar. PALCUS made that happen. Please become a PALCUS member. There are actually some really great benefits to becoming a member, not just these webinars. So even though the webinars are awesome, but there's some really great membership benefits to becoming a member. It only starts at $50 for the year, so very affordable, and you get lots of cool benefits. So thank you very much. Thank you, Sandra. This has been amazing. And we look forward to working with your team on future topics and educating our community. Thank you so much.
Thank you so much.
All
See you
righty.
next time. It was a great pleasure to be part of this. I hope I was clear enough because you made quite complicated questions.
Hey, we like complicated, you know.
Yes, but I like it. I love it. I love it. But it, I think it might be difficult to get a clear message in that regard. But I hope I was clear. But as a disclaimer, if you have additional questions, reach out to us. We will do a free Zoom for the first 30 persons that contact us. Okay.
Excellent. Thank you. And so be sure you say, I saw the PALCUS webinar, and so
Yes.
I want my free consultation. So there you go.
Thank
Excellent.
you so much. It
Thank
was
you
great.
so much. All
Thank
right.
you. Bye.
Próxima.